From the main list, item number 1.
In preparing the appeal, there is a delay of 194 days, my lord. And
what is the appeal about?
My lord, the brief facts of the case, my lord. The appellant, before your lordship, he was the assistant commandant. He was basically a medical officer, your lordship, in Assam Rifle. So there are two charges. One is 2010, he was overstayed while proceeded on leave for 28 days. And 2012, my lord, he proceeded with sanction leave for 19 days and overstayed 439 days, your lordship, because of his mother ailment, your lordship. It was a compelling circumstances. It was not willful, your lordship. He has also duly informed the commandant. When
did he inform the commandant?
My lord, that is recorded in the judgment itself.
No.
At the initial stage, after the expiry.
Sorry, we'll look into the judgment, but are we not entitled to ask you when did he?
My lord, definitely. My lord. Lordship will find. Application dated 5/3/2012.
And when did he go on leave?
My lord, he has gone on leave, my lord, 5th March 2012.
5th March 2012?
12.
And he applied on 5th April?
5th March, my lord.
No, 5th March he went on leave?
Yes.
And when did he apply? For extension?
On 12/3/2012, we informed 12th March.
And how long did he say he will take?
439 days.
He said he will take 439 days.
Total absence, my lord. Total period of absence. And my lord, your lordship, my three grounds, my lord. Grounds are that the penalty order only communicated 4 lines penalty order, court of inquiry held, and 3 lines penalty order, your lordship. Actual penalty order was not served. Appellate order also 3 lines, your lordship. Only that the confirming authority in the penalty order, it says the confirming authority has held you guilty, and therefore you are imposed penalty of compulsory retirement and discharge from service. I want to show these 2 documents, your lordship. This is very vital, and there is no finding that it was willful or under the compelling circumstance. That findings of the disciplinary authority was never served upon the appellant, your lordship. And the actual appellate order also not served. It was only intimated that appellate authority rejected your appeal. And there is no findings.
Is there a speaking
no speaking order. No inquiry report also not served.
Is there a speaking order?
But he was tried by court martial.
Yes.
My lord, the case of their case before the learned single judge was
to hear the case.
My lord.
That he has no chance.
My lord.
But we want to know whether there was a speaking order in either case.
My lord, this court martial orders, my lord, are not required to be very detailed order, my lord. He was given ample opportunity of defending himself, my lord. My lord, their case basically was that they were relying on Asil versus Karunakarn, my lord. That inquiry report was not given to. My lord, that is not even applicable in the present case.
Not even applicable. After that, the constitutional amendment has taken place.
And moreover, because we was tried by Assam Rifle Court, my lord, court martial. So those are civil under CCS rules, my lord.
No,
those are not applicable at all.
Yes.
My lord, only maybe looked into these 2 documents, your lordship. On the page 93.
We all have had mothers for 39 days for mother.
My lord, even no finding
in a discipline force.
Even no
finding is necessary. it's so absurd, the excuse, that no finding is necessary.
Moreover, my lord, 3 years earlier, before, he was again absent for 450 days, my lord.
He says 122 days, and he says 22 days.
On earlier occasion, my lord.
So that has been taken into account.
My lord, no, these proceedings were only for 439 days, my lord.
Yes. And what is his previous record?
Previous record is that in 2008 he was absent for 450 days, my lord.
Yes.
In 2010 he was again absent for 28 days, my lord. And this time in 2012-13,
39.
439 days, my lord.
My lord, there are two charges only on record. 28 days in 2010 and 439 days in 2012. That is the two charges on record.
But when you come to a court of equity under 226, we will look into your general record.
My lord, that is no higher, my lord, in the proceeding.
May not be, but you deny it. File an affidavit and deny it.
My lord, I have no
affidavit and deny it.
on that ground. This is for the first time I have come to learn.
No, sir, you are aware of it.
My lord, this is for
No.
the first time, my lord, fairly speaking.
Anyway,
For the first time, my lord.
your case otherwise is also ridiculous.
Only these two order lordship may look into.
Nothing. Where are the orders?
My lord, page 93,
Page-
penalty order.
Page 93, penalty order.
Yes.
Where do we find the court martial rules?
The rules, my lord. There's an entire chapter on that, my lord, under the Assam Rifle rules, my lord. Lord, I have only one copy, my lord.
Do you have one?
Sorry, my lord. No.
See whether it is anything else. Somebody please. Somebody, no chance. You have one? Oh, page 187, huh?
Yes.
Chapter 9 deals with court martial.
Chapter
Chapter 9.
9. Chapter 9 is charges.
My lord, from charges onwards, my lord, how the defense witnesses are to be examined and framing of charges, my lord.
These are the 2010 rules.
2010 or 2011? 2010.
2010.
Chapter? No, I don't have a same page. No. Chapter 8. Rule. Choice of jurisdiction for court and criminal court. 8. Investigation as a summary disposal. Was this a court of inquiry?
Yes, my lord.
Court of inquiry followed by summary of evidence, my lord, and then court martial.
So court of inquiry is covered by 15. Chapter 15. Why are you giving us chapter 9?
My lord, court of inquiry is in regulations, my lord.
Court of inquiry?
Is under the regulations, my lord, some rifle regulations.
Assam Rifle rules.
My lord, there's
Court of
a,
inquiry is chapter 15.
my lord, that is only brief. How the court of inquiry is to be conducted is under Assam rifle regulations, my lord.
Was there an order over here for it to be tried by a summary Assam Rifles court?
There was an order after court of inquiry. My lord, normally what happens, my lord, to establish prima facie case, there is a court of inquiry, my lord. After that, if the conclusion of the court of inquiry is that yes, there is some material, prima facie material, my lord, then summary of evidence is recorded, and thereafter, on the basis of that,
Now come to rule 47(4). First 46. Is this an offence punishable under the Act? There is an Assam Rifles Act.
yes, my lord,
Is this an offence punishable under the Act?
yes, my lord.
Under which provision of the Act?
Section 26, my lord.
Section?
26 of that.
For absence without leave.
Any person subject to this act who commits any of the following offences, that is to say, absent himself without leave.
Very good. Now, who is a specified officer under section 62?
Commandant, my lord.
Commandant. Very good. Now, tell us, when does a matter, is there any distinction in the rules for a matter to go to be dealt with by the commandant or the matter to be dealt with by a court of inquiry?
Well, commandant has limited powers, my lord. Under section 62, it says that commandant can inflict one or more of the following punishment, that is to say, imprisonment in forced custody up to 28 days, detention up to 28 days, confinement to the lines up to 28 days.
Is there, does section 26
My lord.
provide for major punishment, minor punishment? Or is there any other provision for major punishment, minor punishment?
My lord, section 26 says, my lord, shall on conviction by an Assam Rifle Court,
Yes.
shall on conviction by an Assam Rifle Court be liable to suffer imprisonment for a term which may extend to 3 years or such less punishment as in this act mentioned.
Or such.
Or such less punishment as in this act mentioned.
So where is in this act punishment of compulsory retirement?
My lord. Section 57, my lord.
What does it say?
It says, my lord, the punishments that can be awarded by Assam Rifles Court, my lord. It starts with the death.
In respect of offences under section 26.
My lord, these are the overall powers, my lord. Assam Rifle Court can award punishment of death, imprisonment, dismissal from service, compulsory retirement from service.
That's because just like the BSF court,
My lord.
offences committed outside can also be tried. Like even in the army, offences committed outside can be tried by an army court instead of a regular civilian court.
My lord.
These are disciplined forces.
My lord.
So it will be reserved for those offences in the line of duty.
My lord.
Would it attract a punishment of compulsory retirement? One copy only. We will look only at the authority. We are completely dissatisfied with the cause. But we will look at the procedural fairness and the authority to proceed. Because you have to do it in accordance with law. You can't do it, extrajudicially.
My lord, we have to follow the full procedure, my lord.
Explain the procedure to us. In what cases will it go before commandant? In what cases will it go before court of inquiry?
My lord, court of inquiry is just like a preliminary investigation, my lord.
Very well. After court of inquiry does.
After court of inquiry
Who is
comes
the disciplinary authority?
then there is a summary of evidence, my lord. That is the second stage
Yes.
for obtaining some kind of satisfaction, my lord, whether some material is there or not. After summary of evidence,
Is that evidence supplied to
supplied to
the
him, my lord, that is on record, my lord.
court of inquiry? Report is supplied to the delinquent.
My lord,
Not
page,
supplied.
my lord, page 119, my
Your
lord.
result in the judgment.
He has received, my lord,
Page 119
of the paper book, my lord.
of the paper book. Yes, she has received. Now this is part of his annexures.
My lord.
Now when you say, sir, you have not received it?
To inquiry proceeding, my lord.
Yes.
Inquiry proceeding under section that was also put in the improved judgment.
Please come to page 119. Look at item C, item D.
Court of CO5, my lord, there is court of inquiry also supplied to him, my lord.
So 14 pages of that, 11 pages of this, summary of evidence in respect of both. These are documents appended by you.
This is, my lord, this is court of inquiry, not the general court of inquiry. This is a report of the court of inquiry.
Very well. Court of inquiry report you have, summary of evidence you have.
Yes, my lord.
Very
That
good.
is there.
Then thereafter what happens?
Thereafter, the trials begins, my lord, before the court martial.
General courts of Assam.
So who conducts the trial?
In this case, my lord,
This report is a fact-finding inquiry report.
the constitution of court martial is under in the rules, my lord. Sometimes a 3-member, sometimes a 5-member also. Decided over by commandant, my lord. I can,
You take this, give me a copy of the rules, return the copy of the rules to him. We have another rules. Under which rule, sir?
well,
This is Act. Before that, Dr. Musga, come to section 26. B, without sufficient cause, overstay is deemed granted to him.
Well.
This would apply. Then come to the end.
G, my lord.
On conviction by an Assam Rifles court, so that court has to be constituted,
My lord.
be liable to suffer imprisonment for a term which may extend to 3 years or such less punishment as in this act mentioned.
My lord.
Where is compulsory retirement?
My lord. Section 57, my lord, lordship comes.
57.
B is imprisonment which may...
Just a second. Punishments may be inflicted in respect of offences committed by a person subject to this act and convicted according to the scale following, that is to say, death, imprisonment, dismissal, compulsory retirement.
So, my lord, he was liable for clause B, my lord, imprisonment, but instead of that, he has been given only a reduced lesser punishment, my lord. Of
Clause B for life.
Or any other lesser term, my lord. Imprisonment?
No, but if you say that for absence without sufficient cause, he is liable to life imprisonment, we'll strike it out.
No, my lord, may I read this once again, my lord. It says, my lord, imprisonment which may be for the term of life or any other lesser term, but excluding imprisonment for a term not exceeding 3 months if in forced custody. So the 3 years imprisonment, my lord, under section 26 will fall in this category, my lord.
On the face of it, 57 appears to be completely unreasonable because it makes no distinction between offences and punishments. It says punishments may be inflicted in respect of offences committed by persons subject to this act. Will absence without leave be an offence within the meaning of this act?
Yes, my lord. Section 26.
Section 26 does not say commits any of the following offences. Yes. So therefore, will a person who overstays his deed be liable to death penalty?
3 years, my lord.
Why? Where does it say?
Section 26, my lord. Which may extend to 3 years or such lesser punishment, my lord.
And how is compulsory retirement less punishment than 3 years imprisonment?
My lord, imprisonment for 3 years will automatically entail dismissal from service, my lord.
Where do you find that?
Section 63, my lord, I'll just...
Section 62 is minor punishments. (57) maybe. Punishment or each of the punishments specified in subsection 1 shall be deemed to be inferior in degree to every punishment preceding it in the above scale.
My lord.
That is all right. But on the face of it, it appears that absence or extended leave without sufficient cause would entail death penalty. That cannot be.
3 years imprisonment, my lord.
Where does it specify?
Section 26, my lord, it says that up to 3 years, my lord.
Very well, up to 3 years.
My lord. Now, clause B of section 57 covers from life imprisonment up to 3 months, my lord. 3 months and above and below life, up to life imprisonment, my lord.
Imprisonment which may be for the term of life or any other lesser term, but excluding imprisonment for a term not exceeding 3 months in forced custody. And where is this thing of severance because of imprisonment? $60. Retention in the force of a person convicted on active duty. When on active duty, would he be on active duty?
Till terminated in my humble submission will be deemed to be an active duty, my lord.
Unless your rules provide for it, rules provide 3 years imprisonment.
My lord.
Which means after 3 years imprisonment, he would have served out and he is entitled to get back to the job. Where do the rules provide? 3 years imprisonment plus termination?
$63 talks about award of 2 or more punishments, my lord.
60?
3, my lord. What is it?
63 covers 62.
62.
62 covers only minor punishments, not relevant for us. There is no doubt that 57, in terms of 57(2), like the Hindu Succession Act, they follow serially. Death is the highest grade, imprisonment for life is the next, imprisonment for any term other than in post custody for 3 months, then is removal for service, then is compulsory retirement. All of them go in that hierarchy. The next one is lesser than the previous one.
But here, my lord, instead of, because the court
He would prefer to be imprisoned for 3 years and then get back his service. It does not say imprisonment for 3 years would entail removal from service. In case of death, he can't get it back. In case of life imprisonment, he can't get it back. But in case of imprisonment for any other term, that's the punishment. You can't combine that with removal from service.
there is some problem, my lord. I'm just missing out on that. But conviction by a criminal court, my lord, in other jurisprudence, my lord.
But this is a court by itself.
My lord.
You can't look into other jurisprudence or other statutes for that. Yes, then tell us what happened in his case after 119. He was served the papers which are recorded at 119. After that, what happened?
My lord, after that, the court martial, the promoter, all the papers are not on record, my lord.
Did you file an affidavit before the first court?
Yes, my lord.
Where is your affidavit? You must have put in the incomplete papers.
My affidavit is split 102, my lord. From 100 to 102, my lord.
102. No, this is your affidavit.
Affidavit.
We want the documents. We don't want to read. After 119, what happened? How was the constitution of the body that would hear the matter? Where is that? Then where is the decision of that body?
This is not on record, my lord. Only the sentencing part, my lord, only that is on record, my lord.
Only the?
Sentencing part, my lord. Because after the court martial gives its finding, my lord, there is a promulgation of that order, my lord. Only the promulgation order is available, my lord, that page.
Did he plead guilty?
He pleaded guilty also. And 115 is the promulgation order, my lord. Thereafter, he filed an appeal, my lord. The appeal is rejected also.
Let file all the documents, make a compilation of all the documents,
My lord.
give a copy to him. We'll only look at the procedural fairness because we will not go into the, he's pleaded guilty, we will not go into your discretion, discipline force, it is there, but we must see that it's been done in accordance with law, not that it's been done. And please tell your clients that it is, even though 57 records that any term of imprisonment other than enforced custody for 3 months will be a higher punishment, but it will be double jeopardy. They suffer the punishment of imprisonment and that must be complete. Of course, in case of death, in case of life, it goes without saying. But let's say I'm in prison for 4 months, 8 months, 1 year. How is it obvious that I'll also lose my service? Because that's another mode of punishment. That will mean 57C plus DYE. An act cannot be vague.
Only with regard to that provision, my lord, that imprisonment for a certain term and onwards, my lord, or
Any form of imprisonment
will automatically entail dismissal from.
will entail dismissal. Because otherwise, what follows imprisonment is removal from service, then is compulsory retirement. I think that's the order. Removal from service, of course, has a different meaning.
Well,
Compulsory retirement has a different meaning. Removal from service, you cannot apply again anywhere. Compulsory retirement, subject to
Well,
qualifications you may. We are not impressed with the reasons. We are happy that in a disciplined force, this is the punishment which it deserves. But at least procedural integrity must be maintained.
my lord, what happened, my lord, in the writ petition, there were no pleadings or averments to that effect, my lord. So accordingly, we did not respond to that, my lord. The only case in the writ petition was that they are relying on the Karunakar case, my lord. That copy of inquiry report is not given to us. I appeared before the learned single judge also, my lord. That was the only case, my lord, met out with them.
Copy of what inquiry?
Inquiry report in terms of CCS rules, my lord. After the inquiry officer conducts an inquiry under this Karunakar Electronic Corporation versus so and so, the inquiry must be furnished.
In Karunakar, it says that first, the disciplinary authority appoints an inquiry officer.
Well,
He gets an opportunity to appear before the inquiry officer, cross-examination, everything.
my lord.
documents to be relied upon by the inquiry officer have to be made available to him. Then the inquiry officer furnishes a report. That report is given to the disciplinary authority, not to him. Then the disciplinary authority will consider it and will consider the recommendation. The disciplinary authority has three things to do. One, it can throw it in the waste paper basket and tell the delinquent, you're absolved. Then it can accept the recommendation, call for an answer as to why this punishment should not be given to you. And third, it can return it to the inquiry officer saying that I'm not happy, additional recommendation ought to have been made as regards punishment, you look into it afresh. And it will give notice of that to the delinquent. These are the three courses of action available. In the first case, he does not react. In the second and third cases, he can react. Now, once he reacts, in the second case, the disciplinary authority will have to consider his reaction to the inquiry report before a decision is made whether to accept it to a lesser degree, throw it out, or accept it in full. In the second case, the disciplinary authority has to look into his representation as to whether on the basis of the representation, he would still require the inquiry officer to go into that. So it's a process of adjudication. In a summary court, this may not be there.
So my lord, before Sangha, in the writ petition, the entire case was that we are entitled to a copy of the inquiry report.
That we are not entitled, but they got the preliminary investigation report.
My lord, our case was that we have supplied him the court of inquiry as well as summary of evidence. So, and secondly, the CCS rules are not applicable per se. But there is no such inquiry by an inquiry officer as is envisaged under the CCS rules, my lord.
But there is a court of inquiry.
There is a court of inquiry, my lord, and that was supplied to him. Not so for us, my lord, in the writ petition there was no occasion, my lord, to supply all those papers. But the case was very on a limited compass, my lord. But I can place the.
Let us see what is the case made out in the writ petition. What are the grounds in the writ petition? Oh, your grounds of appeal are only Karunakar.
Only Karunakar, my lord.
My lord, inquiry report, court of inquiry report I am entitled to, that was observed by the learned single judge. But further of 119, this is, my lord, this is a tentative charge sheet, initial charge sheet. For fact-finding, 119 says it is a fact-finding inquiry, not the general court of inquiry, because it was forwarded then to general court of inquiry. And general court of inquiry,
no.
There is a criminal court, my lord.
Where is general court of inquiry in the rules?
My lord?
Where is the order of dismissal or remove thing?
My lord, page 93, your lord.
93.
In the top, my lord, is a General Assam Rifle Court. That inquiry report not supplied. And no findings, whether willful or sufficient cause.
Yeah. Is there anything in the Act of the Rules which precludes reasons to be furnished?
Section 187.
So today we are in a situation, we have to do it on the basis of every situation. Today we are satisfied that he has no ground. But let us say an arguable defense is made. Let's say a charge of bribery is made out. He gives an alibi, and this is the order. It will never be acceptable, because once he is given an alibi, unless cogent grounds are given to disprove the alibi or to demonstrate that that could not have happened, the decision will be suspect. So we will not look at this in this case when this is a hopeless case. But there are many charges which can be given under the Act. Just acquaint yourself a bit more with the Act and the procedure so that you can submit before us.
But in fact, the last year I was dealing with the army, my lord, then BSF, my lord, and then now some rifles come, my lord. Provisions is more or less similar, my lord, but
Because even if that is the case, over here the charge, the lack of defense to it is so overwhelming that reasons may not be given. We may dispense with. But we must know whether reasons are dispensed with altogether.
I'll place the entire proceedings, my lord.
Yeah, I can read it. Copies of Action of Proceeding, Court of the Proceedings. A person subject to an he's been given that, that's page 190.
This has been given.
This has been given. By force court. Is this General Assam Rifles Court a force court? In the Act, I think.
Yes, it's a force court, my lord.
It is a force court.
But there are different categories of courts depending on the offence, my lord. The summary is security force court, highest is General Assam.
You explain the entire thing to us. Explain the entire thing to us, because we can justify this on itself, saying that this is a case which does not require any reasons.
But in this, these are very objective facts are required, my lord. When he went and when he came back, my lord.
But in a different case, if you say that reasons are not required to be given, then we'll have to check it, because there are many cases. Say, for instance, you charge a person with possession of illegal arms. You charge a person with possession of illegal arms. And I will tell you an actual case which I was called upon to decide. The person was found at New Jalpaiguri station with a bag next to him. The bag contained illegal arms. And those arms were either obtained from or to be distributed to ultras, extremists, especially the Rajvanshis over there. But they couldn't link the bag to him.
It was armed person.
BSF. They couldn't link the bag to him. He had said over and over again that there was another passenger in the same thing, sitting in the same, at the platform, and they could not link the bag to me. When I was taken to the BSF thing over there in New Jalpaiguri station, they have a BSF office. When I was taken over there, that was the first thing I said. I disowned it. So imagine a situation like that. Your ipse dixit won't.
Well,
There has to be some reasonableness.
I'll place them, my lord. The entire proceedings, how the proceeding get taken up.
Not for this case, in any future case if it comes. This is hopeless.
But this question came to me, whether imprisonment for a certain duration will whatever, where is that provision? Today this is coming.
There's a hierarchy of punishment.
My lord.
But that hierarchy of punishment does not say that it will, because let's say you've given him 10 years imprisonment. So his tenure in office goes. But you've given him 5 months imprisonment. He'd gladly suffer 5 months imprisonment to get back the job. Because you can't give him under B, under C in 57 and then also give him under D or E. You have to give only one.
My lord. In certain cases, 2 or more punishments can be given, my lord. The rules provide for that. But I'll come with a clear instruction in that, my lord.
Then in that case, the hierarchy would be wrong.
Where is the provision that imprisonment will necessarily entail dismissal from service, my lord? If that provision is there, my lord, then it will make out a case that that is a higher punishment, my lord.
Next week,
Well,
let the matter appear weekends, particularly for the respondent to indicate the manner in which disciplinary proceedings are conducted in Assam Rifles. This exercise is for our benefit, not for yours.
my lord, I'm a little mixed up, my lord, because last week I was dealing with an army act, my lord, and then a BSF matter also, my lord. So the rules and sections have little.
No, the BSF 1968 rules are complete. There's no gap. Army we don't deal with too much because it goes before the tribunal. But the BSF 168 rules are absolutely complete.
Whether habeas corpus matter was filed, my lord, before your lordship's, my lord. Then I understood the army rules, my lord, that day for that purpose, my lord.
That too, the habeas corpus purpose is bring the body. The moment you know where the body is, habeas corpus is over.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
May please, Lordship.
Appeal against?
Appeal against the order of the learned single bench on dated
Yes.
12.
Yes, what is the matter about?
This is the matter about, regarding the registration of Nogmasip. Actually,
Sorry?
Nogmasip hetman.
Yes.
What happened is that we have filed in, there was an order from the IC Land and Revenue JHDC where he has passed that there was a consensus order by the parties, on the basis of the consensus, the order has been passed. But however, the appellant have strongly objected that, saying there was no consensus. In fact, Lordship, what happened in the court of EM, the appellant, the present appellant had never engaged any counsel or the lawyer, and even they were not even present at the time of where this order dated 28/10/2016 was passed, Your Lordship. Then against that order, the appellant, present appellant has filed an appeal, and the order of the EM was set aside by the chief executive member of the GHDC. Then against the order, the present respondent, private respondent, they filed a petition before this, before the learned single judge, and the single judge, Lordship, they passed an order that failing the order of the EM 28/10/2016, Lordship. And then
That was the order of 28th October 2016.
that is, may I take you to page 51, Your Lordship?
81.
Yes. 28/10/2016. It is at page 51, Lordship.
Now,
Now, Your Lordship, this is the order,
just a second.
Lordship.
Who preferred an appeal against this order?
Lordship, the present appellant, Lordship.
And who are you? You are not Kirit Sangma.
No, we are not Kirti Sangma. Kirti Sangma is the respondent, private respondent.
Very well. So you preferred an appeal.
Before against this order, before
Where is the appellate order?
the appellate order of EM is, Lordship, it is at page, it is 62, Lordship. Page 62. This is the order of the CEM. That order of EM can be appealed before the CEM of JHDC. Lordship.
Of the GHDC.
Lordship.
Just a second.
And this order
Yes,
gets
yes,
us, Lordship.
Come to page 51.
Lordship.
Come to the third paragraph.
Yes, heard both sides for passing this, heard both sides
For passing this consensus order.
consensus order. It is,
Once it's a consensus order, it's not appellable.
yes, Lordship, it is not available, Your Lordship. However, we have even in the contention, we have mentioned, Lordship.
Nothing.
Lordship, may I just submit?
No appeal lies against an order by consent. Elementary.
Lordship, may I just submit, Lordship?
No, it's a question of submission. You submit at your own peril, we'll impose costs on you. It's recorded as a consensus order. How can you prefer an appeal? Even the civil procedure court says the consensus order cannot be appealed against. Consensus is you agreed to the order. If you agreed to an order, how can you be aggrieved by it? Appellant is a person who is aggrieved by an order. If you agreed to an order, you cannot be aggrieved by it.
Lordship, you are absolutely right. But only thing is that because of the advocate, because at that time it seemed this.
The appeal does not lie. You go back before the first forum and you give these excuses. No, I did not consent.
They have not even engaged a lawyer also, it seems,
Bad luck.
at the time.
Bad luck. Bad luck.
Not present.
In view of the good grounds made out, the delay of about 211 days in preparing the appeal is condoned and the appeal is taken on board. Full stop. Paragraph. The matter pertains to the appointment of NOCMA for the Tochopara for the Tochopara 2-19 bracket 16 Aking. Full stop. Paragraph. A writ petition was instituted before the single bench of this court, questioning the propriety of an order dated May 30, 2019, passed by the Chief Executive Member, Garo Hills Autonomous District Council. Full stop. The relevant appeal was apparently filed under section 8 bracket 2 of the Garo Hills Autonomous District bracket social customs and usages bracket closed Validating Act 1958. Paragraph. Such appeal was preferred against an order of October 28, 2016, passed by the executive member, IC Land Revenue, GHADC. Full stop. The relevant order of the revenue official has been appended to the appeal papers. Full stop. In the third paragraph of such order of October 28, 2016, it is recorded as follows. Inter alia, it is recorded, inter alia, as follows, open quote, next line. Heard both sides for passing this consensus order, it is clearly mentioned the fact of the case in detail leading to the filing of the case for NOCMA of Tochapara II-19 bracket 16 Aking. It is the present case of the petitioners and the opposite party and son-in-law and the NOCMA daughter of the existing NOCMA, Srimati Kinti C.H. Sangma, by sidetracking all of them, according to Cheran Dopachi Granding clan people, succession to Nokmaship does not arise, comma, at this juncture, since the present Nokma Srimati Kinti C.H. Sangma is still alive, comma, and performing all the duties of Nokmaship and looking after the aching affairs as routine works of the interest of the clan. Full stop, close quote. Paragraph. The operative parts of the relevant order, comma, obviously by consent of the parties, as indicated in the earlier part of the order, comma, provided as follows, colon, next line. Finally, comma, I thus order that Srimati Kinti C.H. Sangma shall continue to be the Nokma of Tochapara 219, it's Tochapara, T.O. Tochapara 219, bracket 16, till her death, without interference from any must be corner from any, then bracket in bracket italics corner whatsoever, comma, in the matter in the interest of the clan people of the said king in question. Full stop. Paragraph. The present appeal is directed against an order of December 2, 2022, by which the private respondent's writ petition was allowed against the order of May 30, 2019, passed by the executive member of the GHADC, full stop. The order records the fact that the order impugned herein records, that the order dated May 30, 2019 was passed, open quote, without going into the aspects as to whether the said order under appeal was a consensus order, ... close quote. Paragraph. Ordinarily, comma, it is a cardinal principle, comma, applicable in all cases without exception, that a party consenting to an order cannot be a party aggrieved by such order to be entitled to prefer an appeal therefrom. Full stop. It is also a fundamental principle that when a judicial or a quasi-judicial body records a fact as to how the matter was conducted before it, comma, particularly whether the order passed by it was on consent or not, comma, a party aggrieved by such recording would have to return to the forum, return to the same forum by way of a petition or application in the nature of review, semicolon. But when a judicial or a quasi-judicial forum records that an order has been passed on consent, comma, no consenting party would be entitled to prefer an appeal. Full stop. Paragraph. The incidental principle is that leave that. Paragraph. It is such aspect of the matter that weighed with the writ court in the present case. Full stop. The order passed by the revenue official clearly indicated that it was an order passed on consent. Full stop. Though the rest of the relevant paragraph may not have been happily worded, comma, nothing therein detracts from the fact that the relevant forum considered that the opposing parties before it had consented to the form of the order that was passed. Full stop. It is possible, comma, in such a scenario that the forum misconstrued the intention of the parties. It is equally possible that an apparently consenting party may have labored under a misapprehension or may not have consciously accorded consent. Full stop. However, comma, such exceptions to the general rule of not being entitled to assail an order passed by consent would entail that the grievance has to be carried to the same forum to explain to such forum why the recording of the consent had to be undone upon satisfying the forum that the consent may not have been willingly or consciously given. Full stop. Paragraph. It is the bounden duty of any appellate forum entertaining a judicial or quasi-judicial matter to first ascertain whether the appeal is maintainable. Full stop. Since an appeal is a creature of a statute and not an inherent right, comma, an appellate forum has first to assess whether the appeal carried before it falls within the four corners of the appellate provision. Full stop. Even more fundamental is the rule that the appellant must be a person aggrieved by the order under appeal. Full stop. A fortiori, comma, who has consented to an order can never be regarded as a party aggrieved by such orders. Full stop. Paragraph. There is no error committed by the single bench in setting aside the order passed by the executive member of GHADC on May 30, 2019, since the appellate forum could not have been availed of by the writ petitioner herein to challenge an order which was passed upon, comma, what appears to be express consent of the writ petitioner before the revenue official in course of the order dated October 28, 2016 being passed. Full stop. Paragraph. Accordingly, WA number so and so is dismissed.
Please.
The miscellaneous application is disposed of, whatever the number, there will, however, be no orders to cause.
May just Lordship, may just say that I may just allow to go back to the just so pilot.
Not after such a long time.
Because actually, why
You may go back, they may entertain you, but you don't have our blessings. We will not say anything about that. You take a chance.
Our Lordship, I may be just withdraw with liberty
No,
to
sir.
file a revision
No, not at all.
report.
No liberty, no blessings. You go back, we are not precluding you either.
Actually, I filed a revision before the single bench, but he has not entered it.
Division before the single bench.
Yes, but later I withdraw, Lordship. I have indicated in my condition.
No. Yes, call on the next matter.
From the main list, item
Much
number
less,
1.
Lordship.
We have no embarrassment with that death in Patakama. Very well. Since one of us, Bhattacharya J, is not inclined to take up this matter, let it be placed before another division bench. Fair enough. He says he was part of the.
Problem.
But not in the meantime, I just want to make a submission. The Honorable Supreme Court on 8/5, the other day I was arguing on the merit of 306. So the direction given by Honorable Supreme Court is this: notwithstanding whatever has happened in the charge sheet, whatever was raised in the writ petition.
We'll look at it, but this bench can't do.
Lordship, if the writ petition, if that is called, it will be easy in the next date of hearing. Otherwise,
The
again,
petition.
the writ petition which was.
You show us when the matter appears before us, shows the writ petition. We'll look at it.
Lordship, we do, maybe the record has to be called for.
Very well.
I don't know.
Whenever it appears, we can't make it part of this order.
Lordship, yes.
But whenever it comes, ensure that the writ petition is in court.
Lordship, yes. Only that. But.
Thank you.
Problem.
Item number 2.
Lordship, this matter, Your Lordship, the postmaster has written a letter saying that we have given the insufficient address. So they have written saying that they are not able to deliver the notice to the private respondent.
You take steps.
Lordship, I take a precedent.
Since service is still not complete, let the matter appear a further 3 weeks hence. You are appearing, madam, for
Respondent 123, JHDC.
respond number?
123.
Yeah, for the JHDC.
Yes, on behalf of Mr. SD.
The unserved respondents should be served immediately. Full stop. It is recorded that the Garo Hills Autonomous District Council is represented.
Lordship, may also allow with the dusty service, Lordship, because as well as dusty personal service. If,
We have not any form of service which we are satisfied they've actually received.
yes, we may be reflected because sometimes they may don't allow.
Yes.
Item number 3.
Much obliged, Lordship.